Good afternoon. My name's Ed Owen. I'm the Director of Communications at HM Courts and Tribunals Service, and I'm delighted to welcome you all to this latest event to engage and discuss the wider reform programme with legal practitioners and legal professionals and other practitioners. Our focus today will be on tribunals reform, and I'm particularly pleased to say that we will have Daniel Fleury, the Deputy Director for Tribunals at HMCTS, talk about the overall approach to reform within tribunals. And then I'm particularly pleased that we're going to be joined by two tribunal judges, Resident Judge Russell Campbell to talk about the Immigration and Asylum Chamber, and Regional Tribunal Judge Mary Clark to talk about Social Security and Child Support. This obviously is an opportunity for you as attendees, virtual attendees to this session, to hear more about reform and to hear some of the detail of reform in those particular jurisdictions. But it's also an opportunity for you to ask questions of those on the panel to understand and get them to engage some of your queries and issues that you may have. So please do submit questions through the presentations. Those you'll see on your screen a box where it is where you're able to submit those written questions, and we will endeavour to answer as many of those as possible within the hour. And for those that we can't answer, we will make sure that we will answer summaries of them and put them onto our website as soon as we can. You will have a copy of the HMCTS website on your invitation email. That website has a lot of information about the wider reform programme, which please do take the opportunity to visit and to look at the information that is available there, which I hope is helpful to you as legal professionals and practitioners. So please keep those questions coming throughout the hour. Just a final point to make about IT issues. If you are having any trouble with the audio with this webinar, then please do dial in. You can dial in via telephone. You won't be able to see the proceedings in the way that you can online, but you will be able to listen to what is said. So please do that, and that number is on your confirmation email. So without further ado, I'd like to introduce Daniel Fleury, who's Deputy Director for Tribunals at HMCTS. Daniel.
Thank you, Ed. Good afternoon, everyone. As I said, I'm Daniel Fleury, Deputy Director of Tribunals in HMCTS. I'm responsible for the various projects underway in the Unified Tribunal System. Tribunal reform is part of the wider HMCTS reform programme, and that programme itself adheres to a number of guiding principles. Those include accessibility, ensuring the sort of financial viability of the system that is transparent, accountable and continually reviewed, a system that is designed for life in 2050 rather than just tomorrow, and a system that is built in partnership with those who use it, those around us, and I think that's perfectly exemplified by the fact I'm sitting here with two judicial colleagues here today to talk about the projects. I think, but critically in all of these guiding principles, I think perhaps the most important one for all is this opportunity we have to sort of strengthen our strong, independent and trusted justice system. And I think that's probably one of the greatest opportunities HMCTS reform gives us. In terms of the projects itself, just to sort of set out a little of what we have done so far and what we intend to do in the near future. I'll begin with the project we've had underway now for 3 years on the Social Security and Child Support Tribunal. We've taken a number of things to improve the system. The first being the ability for appellants to submit their appeal online for both personal independence payments and employment support allowance appeals, and to also track those the progress of their appeal through the receipt of text messages in line with sort of updates on the progress of their appeal. It's been a success. We've had large numbers of appellants taking up. We've had so far over 14,000 appeals. We've had a very positive level of feedback, a satisfaction rate of over 75%. and the system is working well. It's the same with track your appeal. We know from working with our telephone contact centres and so on that large numbers of calls are generated by people ringing up asking about the status of their appeal, and track your appeal, of course, is an easy and convenient way for both HMCTS and for the appellant to understand where their appeal is in the system. In terms of immigration and asylum, this project's been underway since February of last year, and we are a little more in the foothills of this project, but we've launched pilots for asylum appeals in our Manchester and Taylor House hearing centres, and invited a number of firms and solicitors to participate. And again, it's been, while small, it's been warmly welcomed, and we've had over 33 appeals received through this route so far, with the first hearing taking place next week. In terms of what's to come, in the next few weeks, we will launch the Continuous Online Resolution Service, which is an application which will allow appellants who are appealing against decisions made in personal independence payment decisions to essentially seek to resolve their appeal online. And we'll talk a little more about that later, but essentially gives appellants the opportunity, should their appeal be deemed suitable for online resolution, to have their appeal potentially resolved in a time, place, manner of their choosing. We've also extended the online appeal system to Scotland, which we will do so next week, which will then complete the ability to submit an appeal online throughout the whole of the UK. And then we will have also introduced a new case management system in the employment tribunal, which is the same system that we will have introduced in IAC and SSCS. And before the year is out, we will also shortly introduce a project that will seek to reform the residual tribunals, such as war pensions, such as property, such as mental health, and so on. But that's all from me for now. I'd like to hand over to one of my judicial colleagues, to Judge Russell Campbell, who's resident judge of the Taylor House Immigration Centre, for a judicial perspective on
Thank you, Daniel. Well, let me just say a little bit about our particular chamber, where we deal with asylum and human rights cases. In the existing model, business as usual if you want, we've grappled for years with several important problems that amount to barriers to access to justice. One of them is delays in appeals. One of them is the complexity of the work we do, which in a way inhibits the parties from engaging with each other's cases until the last minute. And then a substantial use of paper, really huge bundles arriving at the last minute. So we're very keen to engage in reform. And as Daniel mentioned, we've run a pilot. We're running a pilot now in London and Manchester, where we have in fact 36, not 33 appeals, Daniel. 3 more have arrived. And the first few are being listed next week and the week after. There are 2 aspects to what we're doing that are important to mention in the reform project that we're running. One is the technical side, where for the first time we will be able to offer an online end-to-end appeal process. So the response to the decision to remove somebody or refuse them entry is made online. The case management as we go through the process is online. The documents arrive there. They can be navigated online. And then we get everything ready for the hearing, again online, and the parties prepare their cases in that way. And then in terms of the case management, the rules that go alongside that, we're using our existing powers, but we hope that the rules will change in due course to reflect the reform agenda, to focus the parties' minds early on in the process, instead of what happens too much now. Everything happens at the last minute. The activity is late in the day. The early signs in the first handful of appeals ready to be heard in this way are positive. They're encouraging. We've had the parties knowing more about each other's case early on, feeling in a position where particularly the Home Office, the respondent, can concede points. All of that has the effect of narrowing the issues, which will produce a swifter judgment, likely to be shorter. Everybody benefits. So that's a quick snapshot of where we are in the IAC.
Thank you, Russell. And for a review on SSCS, if I could introduce Mary Clark.
Thank you. Thank you, Daniel. Good afternoon, everybody. I'd like to just begin by picking up on what Daniel said to you about a strong, independent and trusted justice system. I'd like to say a little bit more about reform in social security and child support from a judicial perspective. The first thing to make clear is that the judiciary in social security and child support are committed to embracing the most efficient and effective way of working, whilst ensuring that the justice system retains the reputation it's earned over many years. And this is a position which is fully endorsed by the Chamber President and by the Senior President of tribunals. And it's to ensure that this happens that senior judges from the jurisdiction have been closely involved from the start of the reform process, which Daniel mentioned was in 2016. This to ensure that it does deliver justice and tests out the premise that it can provide the service needed to all users. And in that description, of course, I include appellants, the first tier agencies, and the judges and administrators. The senior judges who are involved in the project are there to challenge and test the perceptions and ideas as they develop, and not to come in at the end simply to say that there are problems that mean it won't work. And to achieve this, we have senior judges on the reform board of the social security and child support reform process, and senior judges as well embedded in the project itself. And they are rigorously testing the systems, processes and procedures and perceptions to make sure that they're fit for purpose before they are rolled out more widely. And perhaps this explains to you why it has been some years since this project commenced, and why we are now planning on rolling out and testing continuous online resolution. The judges have worked with the designers and researchers and developers to test the new system, and of course further testing and evaluation will take place over the weeks ahead. One of the primary concerns is that the system that develops ensures the participation of those who wish to engage, whether by way of face-to-face oral hearing as at present, or by use of new technological systems that do not require the parties to attend in person, yet still enables them to participate. And those of you who know and understand our users will be aware that parties to an appeal may have different needs. They may be vulnerable. Some do not have English as their first language, and some have literacy difficulties and communication problems. This means that one size does not fit all, and different arrangements need to be developed to meet those needs. At present, for example, if an appellant wishes to be involved in their appeal but is unable to travel to a centre, doesn't feel confident enough to engage by phone, then it's difficult for them to make representations except by way of a letter or written submission, and this may present difficulties for them as well. Continuous online resolution will allow those people to engage by responding to questions posed by the tribunal and by providing further evidence electronically, so that they can participate as fully as they are able to. But it's important, and very important, to stress that those who wish to attend an oral hearing face-to-face will continue to have the opportunity to do so. The judicial participation in the project has monitored every stage of the project to ensure that it's compliant with the tribunal procedure rules. In the test environment, we know that there is no necessity to make changes at present, but as soon as the judiciary decide that this is necessary, then appropriate representations will be put forward to the Rules Committee for them to scrutinise and consider. So I hope that just brief introduction sort of sums up the judicial involvement, the judicial interest and support. Thank you.
Thank you very much. That was really informative. Thank you, Mary, Russell, and Daniel. And so I'm going to start on some questions. We've had lots of questions submitted, but please do keep them going. But I'm going to start with you, Daniel. I've got a question here from an advocate who says, I've experienced technology failing, including video links not working during distressing hearings and not being able to get good quality sound during a telephone hearing. How can we be confident that continuous online resolution will be any different and not just result in more delays?
Before I come to the point and answer the question directly, I just sort of set a bit more context around core, which I think will partially answer this question. Core is online resolution is different from a video hearing or from a telephone hearing, is because it's what we call asynchronous chat. The panel will convene, will generate a number of questions they wish to ask of the appellant. Those questions will then be sent to the appellant. They will be given 7 days in which to respond to those questions, but in some ways, the time and place the appellant answers those questions is for the appellant's choosing. So there isn't the immediacy of any potential failure in video links or telephone hearings, and it will just be a case of the appellant logging onto the system after receiving an email alerting him or her to do so, and then responding to the questions the tribunal has set. So I'm hoping that today's issues with technology will be minimized, but in direct response to the question, this is why we are testing online resolution in such a small, limited way over the months ahead. We hope to resolve 250 appeals through online resolution, but part of the test that we will be undertaking is not just whether we can resolve appeals in this way, but also that the technology does what we expect it to do, and appellants can easily understand what is asked for them and respond accordingly. So I am broadly confident that online resolution will work. You know, I think I don't think it can be categorized alongside video hearings and telephone hearings as just another piece of technology, because it is quite a different approach, but I think some of our testing will bear out that point, I hope.
Thank you. I'm going to turn to you, Mary, if I may. Yes. In the Social Security and Child Support Tribunal, we have a question actually from a tribunal member who says, will most of our appellants in SSCS, that is those who are disadvantaged and in general unable to use a computer confidently and effectively, still have the opportunity to have their appeals heard by a 3-member panel as they do now? And there's a sort of follow-up question to that, is who will decide whether they will to have their appeal heard face-to-face by a 3-member panel? So 2 questions there.
Yes, 2 questions. I think the short answer is yes, appellants in the Social Security and Child Support jurisdiction will still have an opportunity to have their appeals heard on a face-to-face basis, as they do at present. You may or may not be aware that our Chamber President was interviewed by Joshua Rosenberg for the BBC last week, and his interview can be accessed on iPlayer even now. So that you will hear him say that there is not any plan to remove the opportunity for appellants to still have their appeals heard orally as they do at present. Moving on to the 3-member panel aspect of the question, the composition of a tribunal is not governed by the judges, it's governed by the composition of tribunals order, which dates back to 2008 and was signed off by the then senior president. And that provides very clearly for the composition of a tribunal in different areas of the jurisdiction. And without a change to that order, there is no possibility of changing the composition of the tribunal. And so far as I'm aware at present, there are no plans to change that immediately.
Thank you very much, Mary. Turning to immigration and asylum, Russell, we've got a question here from a lawyer who says that he or she understands that as part of the pilot scheme, there's the use of tribunal caseworkers, and the lawyer is particularly interested in your opinion of this change, and how can you be confident that these tribunal caseworkers will have enough training to understand the cases?
Yes, it's a good question, but my immediate response is that it's a positive change from the judicial point of view. Tribunal caseworkers are not judges. They are broadly paralegals. They have delegated powers approved by the senior president, and their focus is case management. But the intention is that they will provide intensive dialogue and engagement with the parties from the outset all the way through, so that an appeal is ready to go. If you compare that broadly with the way that we have historically done things, certainly in the IAC, and I'm aware in courts and other tribunals too, the case management by judges has been intermittent and occasional, and usually on application by the parties. In the pilot, what we've noticed is that having the tribunal caseworkers looking at what's coming in, the evidence, the submissions, the skeleton arguments, as the events occur, as they occur online and are visible in that way, there's a real possibility to improve the conduct of the litigation and to assist the tribunal and, more importantly, the parties. So we're seeing cases narrowed in scope. We're seeing the quality of skeleton arguments improved by means of sensible questions from the caseworkers to the representatives to clarify the case. To allay a concern, everything that is done by tribunal caseworkers is subject to review by a judge. Either party can ask for a decision by a caseworker to be reviewed by the judge. And again, as these things develop, as each appeal runs its course, there is close contact between the caseworkers and the judges. So any technical issue about what the law might require would usually be a decision either taken by the judge in response to a question from the caseworker, or by the two together. But the casework steps themselves would usually be, at least initially, the work of the caseworkers. But again, positive response from me on that.
Thank you very much, Russell. I'll come back to you, Daniel. Still on the technology side, do you have plans to improve the existing technology in hearings, including video link and telephone hearings, rather than just adding more types of technology?
Yes, we do. For video hearings, for example, we ran a successful pilot last year in the tax tribunal, which proved the concept that video hearings can take place in the certain circumstances for certain appeals in the tribunal. We're looking to sort of take this on to the next level in the next few months and restart a pilot that looks to introduce both new hardware and new software, and again to provide another opportunity, another new way for appellants, for HMRC and others to resolve their appeal via video. In terms of telephone hearings are becoming far more prevalent in particularly the SSES tribunal, and we're working with colleagues in HMCTS operations to introduce new spider phones, new telephones to allow them to undertake more telephone hearings. So yes, there's certainly an investment in the existing technology as well as the online resolution. What I want to sort of say as well is that in terms of hearings, it really isn't a sort of one-size-fits-all approach. And for example, in SSES, we've devoted our time and our effort to introducing online resolution, and at present don't have any plans to introduce video hearings into the tribunal. In IAC, for example, again, we've worked with our judicial colleagues, and whereas the majority of bail hearings are undertaken by video, we don't have plans to significantly expand video hearings in the IAC tribunal. But in terms, back to the question about the technology, yes, the old technology, if I could call it that, will not be forgotten and will continue to be upgraded in line with further rollouts and pilots.
Great, thank you very much. Mary, I'm going to come back to SSES. Quite a lot of questions on SCS issues. We have a question from a welfare benefit advocate. How do we ensure that justice isn't just done, but seen to be done with continuous online resolution? Will people be able to observe a COR session in process, or will there arrangements be made to make sure there's open justice in these cases? I'm really interested to your views as to those issues.
Thank you. Yes, I'm glad that question has been raised. The first thing to say is that no party will participate in continuous online resolution unless they have consented to do so. That process will not be imposed upon anybody. Furthermore, and I see this as an advantage rather than a hindrance, the continuous online resolution system will ensure that there is a complete transcript of the exchanges between the parties. At present, as those of you familiar with tribunal hearings will be aware, it is the role of the tribunal judge to keep a record of proceedings, which can, by its very nature, only be a brief note of the matters that are discussed. But with the COR system, there will be a complete transcript preserved. And at present, the continuous online resolution hearings are conducted in tribunal premises. They're not hidden away. So there's the usual access for observers, though I have to say very little observation of tribunals is taken up. The test environment as it stands comes within the tribunal procedure rules, which again covers the hearing of appeals. And I would like to just add to that of course, justice being seen to be done doesn't just relate to a time and a place, although this is one way of achieving it. The general public are often unwilling, unable, or even not interested in our hearings. However, it remains important that they can understand what we do and that we continue to be accountable and transparent. So we continue to open our doors, though almost nobody comes in. And the public and those who inform them, such as reports and researchers, now use different tools to communicate what we do and how we do it. They may be unfamiliar with our proceedings as members of the public, but in a digital age, they're no less able to discover whether justice is being done and to see how that justice is being done. So that's really what I would like to say about that. Thank you.
Thanks, Mary. I mean, and just to stay on SSCS, because that's where a lot of the questions we're getting are focused. A similar question both from Helen and from Ken, who've both asked, will appellants have to undergo the online resolution process before a face-to-face hearing, or can they opt at the beginning for a face-to-face hearing? And I don't know, Mary, if that's one for you or for one for you, Daniel, which is...
Well, I think between us we can answer that. They can always opt for a face-to-face hearing. It is only when they consent to participate in continuous online resolution that their particular appeal would go forward in that manner. And even when it does go forward in that manner, a judge may decide that it's not the best way for that appeal to proceed, and it will revert back to becoming an oral hearing. So I don't think that as the reform process stands at the moment, that anybody would ever have a COR hearing foisted upon them unwillingly. But I don't know whether you...
Yeah, that's just to reiterate and to stress, no one will be compelled to have an online hearing, an online resolution. As Mary says, it requires the consent of the parties and the panel, really. There's no question that the route to an oral hearing, which will always be the backstop, I guess, for SSCS, will ever be cut off.
Wendy asks that it's great, she says, that the judiciary is involved in testing and development of the aspects we've been talking about, but when do the public or advice agencies get consulted in a meaningful way, and will their views be taken into account? Daniel, do you want to deal with that one?
Yeah, no, we presented our proposals on SSCS in particular to a group that is supported by HMCTS called the Litigant and Person Engagement Group, and members of that group include a number of representatives from the advice sector, Citizens Advice Bureau and so on, and we have a sort of regular dialogue with them about developments to SSCS online resolution, and that development will continue right throughout the lifetime of the project. Same in immigration, you know, we haven't got to at the appellants in person stage just yet, but we've been working very closely with solicitors in the Immigration and Asylum Chamber in support of our 2 pilot areas. So just to sort of reassure those attending today, there is an active dialogue with the advice sector and legal sector, and if there is anything more that we can do or can be done, or people wish to speak to, then we're always keen to engage and consult and discuss.
Can I add something from the IAC? It's a good question from Wendy. In our pilots in London and Manchester, we will have what we call user group meetings, but they're slightly broader than that, as the pilots evolve and come to the final stages. So in London, there's likely to be one of those meetings in late July or August. And we certainly want to cast the net wide. So it'll be the solicitors and the barristers involved in the pilot, but also those who are more concerned, who want to come along to Taylor House and just share their views on the pilot and what reform might mean.
That's very, very useful. And perhaps we will provide.
Perhaps I could just add on from the Social Security and Child Support jurisdiction. We have long had user group meetings to which all stakeholders have been invited, so that we have had representatives and representatives of the first tier agency, exactly as Russell describes, and we have close contact with them. They are always able to put forward their questions inside the forum of a meeting or in between meetings, and there is that engagement.
That's good to hear. Russell, I'm going to come to some questions on the Immigration and Asylum Chamber. So I have some questions here from a charity worker who says, in your pilot, you've cut the fields on the form from 128 to 25. How have you done this without losing important information, and what do you think of this? And then I've got a follow-up question. But
that's fine. Well, let me deal with that first of all. The form mentioned in the question is the notice of appeal, and it's right that for the purpose of the online aspect of the pilot, we've simplified it. We haven't lost important information. What we've done is focus very hard on what's needed to make it as easy as possible for someone with a case to lodge an appeal. And the existing business as usual paper-based form tended to include at that stage questions about the hearing. Do you need an interpreter? Is the layout of the hearing room likely to be right to meet your needs? Those things we haven't forgotten, but we want to keep them, reserve them if you want, until the right time to answer them. And if the pilot works well, by the time we get to that stage, the appeal will be ready to go. So it's about making it easier at the outset, putting the focus where it should be at the beginning.
And a follow-up question from the same person. She understands that part of the pilot has involved introducing an extra check for the Home Office to review their decision. Has this resulted in any decisions being changed when previously they'd have gone to a hearing?
Again, just to explain that, the front loading of all the important steps, if we can achieve it, will mean that both the appellant and the Home Office know each other's case early on, not at the last minute. And from the Home Office perspective, once they've seen what the appellant's case is, they have a real opportunity to decide whether to stick to the adverse decision that gives rise to the appeal. That's the effective review. It's a good innovation. So far, we haven't had any decisions withdrawn, but what we've seen in about 5 or 6 cases is the Home Office narrowing the issues, making concessions, pragmatic ones, once they've seen the evidence that the appellant relies on for the purpose of the appeal. That's a brilliant step. In the past, leaving it all to the last minute would often mean that the first discussion between the appellant's representative and the presenting officer would be outside the courtroom just before the case is called on, when little can be achieved in most cases. So this check, this new check, this effective review is one of the important innovations that we're pleased to promote.
Thank you very much. I'm going to switch back to SSCS. There's a number of questions about the role of representatives in the continuous online resolution process. So one question from John. when the appellant has a representative, will they also get the email alert? Quite a simple issue. Will they get the email alert as well as the appellant?
As you say, I see there's a number of questions about the role of representatives in SSCS, and I'll try and sort of deal with them all now. In terms of the text message, the Track Your Appeals service, yes, representatives could sign up to receive the texts at present. In terms of representatives being able to submit evidence and appeals on behalf of an appellant, we haven't got to that stage just yet, but that is something that we hope to do before the project end. And just finally, on online resolution, I've mentioned the pilot that we're undertaking in the next few months, 250 appeals. We've excluded appeals where the appellant is represented at this stage. That isn't because we do not want representatives to participate in the pilot, but given that we are starting off in a very small and limited way, we've selected appeals, well, a number of factors. For example, appeal where there is, we won't use online resolution to progress an appeal where there is an interpreter and so on. So there's a number of factors that we've excluded at this stage, but we hope to bring in future pilots.
Great, thank you. Another question here from about those who are digitally excluded. What about those appellants who actually want to use continuous online resolution but are digitally excluded? What support will be offered to them? Are they going to be encouraged in the pilot, or is it they going to be later at a later phase? And how will the system support them?
Being frank with you, Ed, whereas we do have what we call an assisted digital program, which supports appellants in submitting an appeal. If an appellant is digitally excluded or unable to use a computer, it's very likely that the panel will consider them unsuitable for online resolution, and the only opportunity they will have to resolve their appeal at this stage is through a telephone hearing or an oral hearing, or for their appeal to be dealt with on the papers. That may change in the long run, but in terms of the initial pilot, if someone presents as digitally excluded, then I think the panel will probably conclude that they're not suitable.
Yeah. I think the whole system is rather dependent upon them having some ability to use digital facilities. I think it would be very, very difficult, and probably not fair to expect them to cope with some situation like that. And I suspect that the panel would come to that conclusion.
Why the further question? Can you explain why PIP appeals were chosen to be the first piece of work that would be trialling the continuous online resolution pilot? What was the thinking behind that?
Well, personal independence payment appeals are the largest number of appeals the SSCS tribunal receives, and if I can be slightly flippant for a moment, it's what I call the sort of New York test. If we could make it with PIP appeals, then I think we could make it with everything else, employment support allowance and so on. And I think that's why we've begun testing with PIP appeals rather than anything else. So in some ways, it's the size or the volume of PIP appeals we receive. We know that PIP appellants are some of the most vulnerable appellants, not just in SSCS, but right across the unified tribunal system. And it's thought if we can provide a service that suits them, then I think the rest will be not a piece of cake, but maybe a little easier.
And obviously in the immigration asylum chamber, you'll be looking at this pilot with great interest. Is it something that you see as a potential benefit within the immigration and asylum chamber?
Certainly. I mean, it's of interest, but remember, in our chamber, historically, there's been far less inclination to settle or resolve things quickly without the appeal being there in the background. So we want to take easy steps, but the analogy with PIP is that we're piloting, if you want, asylum appeals, because that's a large cohort that engages with some of the most important issues. And if we can make it work with that type of case, then we've achieved a great deal. It is expected that eventually, when the pilot goes into what's called a public beta phase in 2020, early on, we may add more categories of case. So in the background, we've got lots of European appeals and lots of entry clearance appeals. where the issues are important. It's usually about separated family members, so the appeals have obvious importance. But if we can make those work as well, they might be added in. But no decisions have been made on that. But we want to get the asylum cases tested first.
I'll stay with you, Russ, if I can, which is another question about the pilot. Will the service be available in other languages, allowing people without representation to lodge an appeal themselves?
It's a good question. The procedure rules emphasise that the language of the tribunal for the purpose of the appeal is English, or in Wales, Welsh or English. There are no plans to change that. But we do want to make the system as accessible as it can be. And so there are proposals to have, ideally, online resources in other languages, so that, for example, an appellant in person, a litigant in person, who just wants to lodge an appeal, whose first language is not English, can use the system. But once it gets into the online phase, at least for the foreseeable future, the proceedings will be conducted in English or in Welsh.
I'm dodging between the two different tribunals here, but going back to SSCS, question from Richard, who says, under the continuous online resolution for SSCS, will there be an opportunity to apply for an extension of the time in which to respond to questions sent by the panel? Our clients, he says, are often very unwell and undergoing treatment, which can incapacitate them for intermittent periods. So is there some reassurance you can give him that there will be some flexibility on timings?
Indeed, I can. The initial period for a response will be 7 days, but there is an opportunity to ask for a further extension for a further 7 days, and then in exceptional circumstances a further extension can be granted if applied for. So there will be quite an extensive period of time allowed where needed, though of course it's hoped that as many people as possible will answer the questions within the first timescale, so that the appeal can be progressed as soon as possible and the appellant can get their outcome decision as soon as possible. But there is that safety net, yes.
I've got two questions on sticking with SSCS. One is from Megan about PIP. One of the biggest complaints we receive is about waiting times for PIP appeals. Will the online system go somewhere to reducing these? Is it your expectation or hope that this will reduce delays?
Not necessarily. Well, it is my hope, but I wouldn't say online resolution is the panacea to delays in terms of dealing with PIP appeals. And I say that for two reasons. One, I don't expect PIP appeals to be any more efficient than an oral hearing. And secondly, the pilot that we have underway in the next few months is so small as to sort of make any significant difference. What will make a difference to the timeliness of PIP appeals is HMCTS, in conjunction with the judiciary, undertook significant levels of recruitment in SSCS over the course of last year. New judges, new disability qualified members, new medical members, and many of them have now taken up post, and we're already seeing improvements to timeliness across the UK in terms of PIP, and I hope very much that will continue over the course of this year.
Just on delays, just a question coming from Helen. I think Helen's been has asked a number of questions. She asks, with online resolution, is there an argument for scrapping mandatory reconsiderations to simplify the system and avoid delays? Mary?
Well, mandatory reconsideration appears in primary legislation, so they would need to have quite a sea change there in areas over which the judiciary don't have control. So that would not be a decision for the judiciary, that would be for a decision for the Department for Work and Pension and for Parliament.
Mike asks about accessibility. I'll read the question in full. Accessibility was mentioned at the outset of this webinar, and the only subsequent mention has been in terms of taking questions out as regards the immigration asylum pilot we talked about earlier. Could someone expand on the specifics of accessibility testing for different impairments for continuous online resolution? I don't know who is best able to sort of perhaps deal with some of the issues around the early testing that took place as part of the COR.
Well, again, COR is in the sort of foothills of development. We haven't got over there. We haven't even we have commenced the pilot. We haven't had a hearing for online resolution just yet. In terms of the impairments, I wonder whether Mike could elaborate himself, whether that's in impairments the appellant faces or some other impairment that the tribunal has to deal with.
Okay, but we'll so Mike, if you've heard Daniel's answer, please do ask a supplementary, which we'll try and provide some further detail on. Now we talked, just going back to the openness question, in SSS appeals, Mary, you talked a bit about the openness of the system. What format would a transcript be provided in? Is it text or video file?
It'll be a text file.
Text file.
Because the questions will be written to, by the tribunal members, and I would like to stress here that it is by all the tribunal members. Every single one will have an opportunity to put forward questions, and will discuss amongst themselves, just as they do at the moment, what would be the appropriate questions to ask. And those will be in text form, and the answers will be in text form. So I think, going back to another questioner's question, that is really why the participants need to have some level of IT understanding.
Yes, that was a question from Valerie. Another question about the sort of practicalities of the system, if you like. Will the online platform be compatible with mobile devices?
Yes, it will.
So and in the testing of that was very much done with the idea that it was accessible as
yes, you know, all of our applications are done in line with the government digital service guidelines, which can be found on all good websites, and yes, they are compatible with many browsers.
Great, thank you all. I'm looking at other questions that we have.
Ed, I saw one on screen from Usman, just an important one about bundles.
Yeah, we just perhaps explain to those who are joining the line. We are seeing a list of questions, and so all the panelists actually are able to see the questions that are coming through. So, Russell.
Yes, so Usman asked whether in the immigration cases the appellants will be able to submit bundles digitally via a portal, as the Home Office are currently able to do. It's a very good question. The answer is yes, absolutely. The aim is that both sides will be able to prepare a bundle. It's digitized, it's online, and that will help the tribunal achieve this desirable outcome in all courts and all tribunals, which is the agreed bundle before the hearing. Hearings go smoothly if both sides know precisely which documents are before the judge or the panel, and so, Usman, yes, appellants will be able to do this. In the pilot, that is one of the things being tested.
Great, thank you, Russell. For both Mary and yourself, Russell, we've had a question which was pre-submitted. So you both have been very much involved in the work which we've talked about today, but looking forward in terms of how new systems get embedded across the system, what training has been given to judges to ensure they feel confident working with digital cases as they do with paper ones?
Well, because I'm involved in the project and because I'm also the National Judicial Training Officer, I am in close contact with the Judicial College to discuss the best and appropriate methods of training. Now, as Daniel has explained, with continuous online resolution, this is still in its very early stages, so a very, very small number of judicial office holders are currently involved in it and have been involved and understand the working of the system. But there are plans to cascade training to others who may become involved as and when the project rolls out further to other regions.
All I'd add to that is that one thing that mustn't be forgotten is that both tribunals, the IAC, SSCS, rely very heavily on fee-paid judges. There's a smaller cohort of salaried judges. I think the training challenges are probably easier to meet with salaried judges, but the fee-paid judges play such a vital role that they mustn't be left behind, and often they're using their own kit. And the other thing I'd say is that whereas in the Crown Court, it looks as though judges, lawyers, witnesses, jury members can see a digital screen with a bundle behind it, so to speak, and work their way through it. That's something that is new to tribunals, and I think just for human beings, that's going to be quite a challenge, getting used to working your way through not a post-it note-ridden bundle of papers, but on a screen with everybody in the hearing room looking at the same page. That's what we've got to achieve.
We've had a sort of follow-up question from Helen from the earlier question about timings of appeals and the extensions and other issues that were raised. She says, I understand that the appellants can ask for extension. However, what will happen if they do not respond? Is there a possibility the appeal will lapse?
Well, it won't lapse, because it would only lapse if a more favourable decision had been made. So it won't lapse. An appeal stands until it has been determined. So if in the event that there was not a response from an appellant, then the most likely next step would be for the tribunal to issue some directions to the appellant, inviting them to respond, inviting them to indicate what problems they have responding, and depending on what they are able to say, then the appeal will move forward in that way. It might be the case, and here I'm talking lots of ifs and buts, but it might be the case that the lack of any response leads the tribunal to conclude that the appeal can no longer proceed under continuous online resolution, and that another method of delivering justice needs to be found, such as an oral face-to-face hearing.
Thank you. Mike has come back. We asked him to ask a supplementary question to Daniel, you were about the accessibility issue that he raised, about accessibility testing for different impairments for continuous online resolution. He's come back to say that impairments in both representatives and appellants. I don't know if that helps clarify the question any more than.
Well, let me try and answer a general point about accessibility and why online resolution, I believe, is one of the ways in which to improve accessibility. We know, again, coming back to PIP appellants, that they are some of the most vulnerable members of our society, and the prospect of travelling for what some may be a relatively long distance to a hearing centre is a daunting experience. And online resolution, as I think I said at the beginning, is an opportunity for them, well, to seek to have their appeal resolved in the time and manner of their choosing. You know, they have the option of a telephone hearing, an oral hearing, having their appeal dealt with in the papers. And I think online resolution just opens up another channel, another avenue by which the appellant can seek to make his or her case and have their appeal resolved. I think that's what I'm trying to sort of get over the accessibility point, that online resolution, one, you've got the ability to submit your appeal online, and then maybe your possibility, an opportunity to have your appeal determined online. So I hope that's what you mean by impairments and so on, but I think that's my wider point about how online resolution does improve, I think, access to justice and accessibility of courts and tribunal services.
Thanks. A good question from Nimrod just coming in, and we're approaching the end of our session, but a question from Nimrod. At the moment, it seems that testing is siloed by product. At what point in the reform programme would it be possible to test the user experience of the new processes from end to end? So, for example, for SSCS appellants from mandatory reconsideration result all the way to DWP implementation of tribunal decision.
Well, I guess that as the programme develops, the best way of describing this is that all the dots will be joined up, so that from the outset, from the lodging of the appeal, which can be online, through to tracking the appeal, through to a choice being made for a continuous online resolution, through to a decision being made, then that then will be a seamless process. At the moment, Daniel may have more to say about this, but it seems we're still joining the different sections up effectively.
We are, and I see the sort of thrust of the question. We work very closely with the Department of Work and Pensions and the Home Office in delivering this project, but reform of the sort of wider mandatory reconsideration, or even further upstream, the benefit claim process is in some ways a matter for DWP. But what this reform does is give us that opportunity to put that building block of digital working in place to allow for appeals to be submitted online, and potentially gives other government departments the opportunity to build on this digital building block that we're providing. So although I can't promise end-to-end working in all non-party to party tribunals, I'd like to think that this HMCTS reform gives us that opportunity to do so.
Thank you very much. Well, we're almost out of time, so I'd like to thank Daniel, Judge Campbell, Judge Clark, and particularly all those who've joined us online for this session and for those submitting questions. It's been a fascinating hour. I'm really grateful to everyone giving up their time. I hope it has been informative and helpful, but this is only one aspect of a wider engagement. There'll be plenty of other opportunities to talk about the wider reform programme and tribunals within it. So I'm really grateful to everyone who's taken part. Today, I can tell you we've had more than 50 questions submitted and more than 150 participants have attended online, so it demonstrates that there is a great appetite out there to receive information and to be able to put their questions to you all, and I'm hugely grateful that you've been open in answering those that we've been able to put to you. There are some further questions that have come in which I haven't been able to put to the panel, and we will endeavour to, as I said earlier, we'll endeavour to put those online on our website. But once again, thank you very much to the panel and to all participants online, and we hope to speak to you soon. Thank you.